California's lemon law is changing in a big way for 2025. The big three car manufacturers have teamed up to make these changes, which are mostly in their favor. Some of these changes may affect whether you qualify. Other changes may affect how much you qualify for. So you have a newer car with some problems and you're looking to do your lemon law homework, you come to the right place. You're going to want to check this out. Together, we'll cover 3 of the biggest changes in the new lemon law for 2025. And make sure to watch until the end where I'll share possibly the biggest change to the law that will affect nearly 2/3 of car buyers. My name is Sina Rezvanpour. Not only am I a huge car fan, but I'm also the founder of Sina Rez Law, a California law firm specializing in lemon law. If you're new to the channel, make sure to subscribe for all of my lemon law tips so you don't get taken advantage of by car manufacturers and to help you get the most money possible. Real quick, let's go over the purpose of the lemon law. It's a consumer-friendly law that protects people who own or lease a newer car with too many problems. California's lemon law says that if you qualify, you can get a refund or a replacement of your car. There's all kinds of criteria on who qualifies or who doesn't qualify, but I'll cover those in a different video. If you have any questions, put them in the comments and I'll make sure to answer all of them. These changes to the lemon law are brand spanking new, and other lawyers or even judges may have different interpretations of this law. Time will tell how these changes will be implemented. The first big change affects who can no longer bring a case. Under the old law, you had 4 years from the time you found out that you may have a lemon to bring a case. That's still true, but now there's some extra deadlines that you have to be careful with. We've already had to say no to a bunch of cases that we would normally be glad to accept, so these new limitations stink. But it's important that you're familiar with these changes and you take action now if you think your car may be a lemon. Let's go into the 6-year rule. You only have 6 years to bring a case from the original sale of your car. If you purchase your car certified pre-owned, the 6-year clock starts from when the car was sold to the first buyer, not you. So let's say you bought a 2018 certified pre-owned Silverado back in 2022, but that Silverado was originally sold in January of 2018. Your rights expired in January of 2024. Sorry, I know this is not fair, but this is the new law for 2025. Essentially, this completely eliminates cases for 2017 models, and it's mostly going to eliminate 2018 models as well. Now let's go into the 1-year rule. The 1-year rule says that you only have 1 year from the expiration of the applicable warranty to bring a case. This can get a little tricky since most cars have more than one warranty. Follow me as we break it down. So let's say you have a 2020 F-150. Your truck comes with a 3-year 36,000 mile warranty and a 5-year 60,000 mile powertrain warranty. If the truck currently has 65,000 miles, we have to ask a few questions to see if it's too late for you to bring a case. To start, we already know that you're safe under the 6-year rule that we just talked about a second ago. First, we'll want to review your repair orders to see if the problems you've had with your truck are under the shortened limited warranty or under the longer powertrain warranty. It's totally possible that you have issues that are covered under both warranties, and in that case, we're going to go with the longer warranty. Next, we need to find out at what point did your 5-year 60,000 mile powertrain warranty expire. We know we're good under the 5 years. We next need to find out at what point did you cross 60,000 miles. Easiest way to do this is to check your repair or maintenance records. Let's say that your record shows 62,000 miles in April of 2024. Then you're likely safe. But if your record shows 62,000 miles in January of 2024 instead of April, then it's likely too late for you to bring a case. Okay, now let's talk about what you're required to do before bringing your lemon law case. The new law does not require you or your lawyer to send a letter to the car manufacturer before filing a lawsuit. But if you want to pursue a civil penalty, then you most likely do have to first start by sending the manufacturer a letter. Really quick, if you're not familiar, civil penalties are a type of extra compensation that you can get back on top of your refund. This penalty is usually meant to punish the car manufacturer for some naughty behavior in your lemon law claim process. This letter has to say some specific things like whether you're asking for a buyback or a replacement of your vehicle. It has to include your VIN, as well as a summary of the problems you've had with your car. Just a quick note, we do this letter for our clients for free. So if you're interested in getting some help with this, I strongly suggest that you reach out to us. Use the link in the description below. There are all kinds of tricks that the car manufacturers play to get out of paying you what you're owed. For example, they may reject your request when they actually should be offering you a buyback, or they may not respond to your letter in time, or they may offer to buy your car back, but for the wrong amount, or they may offer to buy your car back for the right amount, but they never follow through with their offer or don't do it fast enough. Then you can file a lawsuit and pursue civil penalties. These civil penalties can be a ton of money on top of the refund that you're already owed. And this is something else that we do for our clients on a daily basis. Now there's a very structured timeline that we have to follow for the first 150 days of your case. That doesn't mean there won't be plenty of cases that will settle much faster than that. But this change in law is meant to hopefully cut down on some of these cases that take a year or even longer to settle because the car manufacturers have been dragging their feet. For example, in the first 60 days after the manufacturer has answered the lawsuit, both sides have to offer up what we call initial disclosures. This basically means each side has to volunteer or share specific documents and details that will be helpful to move along the case. For example, the car owner needs to provide a copy of their contract, their repair records, registration, payment history, and and a payoff letter from their bank. But here comes the good part. The car manufacturers now also have to share a bunch of documents that we would usually have to fight for. So this will make things a lot easier for us to help you. These are things like technical service bulletins, recalls, and communications between the car manufacturer and the dealership about your car. Within the first 90 days, we have to schedule a mediation. This is an informal attempt to settle your case using a neutral third party. Within the first 120 days, each side can take one deposition. The consumer's lawyer can take the deposition of a representative from the car manufacturer that we usually call the PMK or the PMQ. And the car manufacturer's lawyer can take the deposition of the plaintiff, and that would be you. We used to have 7 hours to do these depositions, but now we're limited to just 2. Within the first 150 days, we have to complete that mediation that was previously scheduled. Remember, mediation usually results in the case settling, but not always. And now, the bonus tip that you all have been waiting for. This may be the biggest change of all to the lemon law. About 2/3 of car purchases are for used cars. The California Supreme Court issued an opinion at the end of 2024 in the infamous Rodriguez v. FCA case on how the lemon law applies to used cars. The lemon law never applied to all car sales. Back in the good old days, cars that were purchased used but still had the remainder of their original warranty in place had lemon law rights. Imagine buying a 2023 Dodge Charger with only 10,000 miles. The car is still pretty new and has plenty of warranty coverage left. Now, as a result of the decision in Rodriguez, this car would most likely not have lemon law rights, with very few exceptions. The most common exception would be if the car was sold certified pre-owned. A car that's CPO is almost always sold by an authorized dealership. So in this example, it would be sold by a Dodge dealership. But that alone isn't enough. CPO means the car is getting an extra warranty at the time of sale. So not only do you most likely have the leftover original warranty, but you also have a brand new CPO warranty. So if you want to have some added protection of the lemon law when buying a used car, make sure that it's not too old and then certified pre-owned from an authorized dealership. There is way too much to cover in just one video. If you have any questions at all, use the link in the description below to connect with our team. We'll be happy to help you find out if you qualify for a settlement. I'm Sina Resvanpour. Thank you for watching. If you want to learn more about the lemon law, then check out one of these other videos.